Hello everyone, this is Tom Fox and I'd like to welcome you to episode 255 of the FCPA Compliance and Ethics Report. The FCPA Compliance and Ethics Report is sponsored by the Red Flag Group. The Red Flag Group is a business advisory, information services, and technology firm that helps clients manage risk across four key areas: sales and sales channels, suppliers, customers, and human capital. I'm also pleased to announce that I will be leading some compliance roundtables for the Red Flag Group in June. We're going to be taking a look at the Unaoil and Panama Papers case and trying to see what are some of the lessons learned and how you can implement those lessons in your compliance program. I will be leading roundtables in Minneapolis, Dallas, Houston, and Atlanta. If you'd like more information, please check out the Red Flag Group at theredflaggroup.com. This is Tom Fox. Thank you very much for listening. Hello everyone, this is Tom Fox. I'd like to welcome you to this episode of the FCPA Compliance and Ethics Report. Today I wanted to visit with you about something that doesn't come up very often, but often enough that I think it's important that you consider, which is the revising of your code of conduct, policies, and procedures. Most compliance practitioners are going to be familiar with risk assessments and how you might incorporate those risk assessments on an ongoing basis going forward. But one of the things that people may not think about as often is when was the last time your code of conduct was revised? When was the last time your FCPA compliance policy was revised? How about the procedures? So I would ask you to answer the question: when was the last time your code of conduct was revised? Have there been any changes to your company's internal policy since the last revision to the code of conduct? Have there been any changes to relevant laws relating to a topic covered in your code of conduct? Are any of the guidelines in your code of conduct outdated? And finally, and this one's near and dear to every corporate officer's heart, is there any budget to create or revise your code of conduct? So after considering these issues, I would suggest that you benchmark your current code of conduct against that of other companies in your industry. I would also add that your standards, policies, and procedures should be reviewed and updated in the same manner. If you decide to move forward, then there's a 6-step process that I would like to lay out for you. So number one, get buy-in from decision makers at the highest levels of your company. You can't say it enough that it starts at tone at the top. But if you're going to have a revision to your code of conduct, this is probably going to have to go to the board level. Your compliance program and policy and procedures may be more in your purview, but the higher level you can get for management to support you, the better off you're going to be. So whoever gives this mandate, though, that person should be consulted at every major step of code review process if it involves a change in direction of key policy. Number two, establish a core revision committee. This needs to be a cross-functional working group to head up your efforts to revise your code of conduct and your compliance policies and procedures. The group should include representatives of legal, compliance, communications, HR. You might often also have marketing. You might also have internal audit. You should have certainly business unit, both domestic and international representation, and IT definitely needs to be a part of this. From this large group, topics can be assigned for initial drafting based on relevancy or necessity. The different functions should also solicit feedback from their peers and deliver a final proposed draft to whoever the drafting committee is. Keep a timeline so that you can hold the representatives accountable for meeting these deliverables. Number three, conduct a thorough technology assessment. The cornerstone of any revision process is how your company captures and collaborates and preserves all of the comments, notes, and edits during the project. Once upon a time, SharePoint did this. Many people used. Google documents is now used, but you need to have a way to capture everything that rolls up into your final product. You should determine if how you want to do hard copies, online copies, or both. But you've got to maintain document control, and you've got to maintain revision control. Fortunately, like I said, there's a number of tools that are out there for you to utilize, and that needs to be a part of your solution going forward. And there has to be a distribution plan. With numbered copies so that you can keep control of who receives what copy. Number 4, determine translations and localizations. If your company does business internationally, you've got to have a code that can translate and then be translated. And I know Mr. Translations out there, Jay Rosen's heart is going to warm when he hears this. But you've got to have a subject matter expert who gives you a certified translation. And you've got to make sure that that translation gets across to the employees who may speak in, obviously, languages other than English, but even derivations of those different languages. So you've got to make it locally available. That's one thing the FCPA guidance made clear, is that your code of conduct, policies, and procedures have to be in local languages. So you're going to need to have a translation plan, and I would even suggest that you have the discussions with your translation partner at a very early and ongoing basis so that you can have the right translations made available when you're ready for rollout. Number 5, develop a communication plan. So you have to have a plan to communicate any revisions to your code of conduct. You need to make it in a way that encourages employees to review and use the code on an ongoing basis. At an earlier podcast, I talked about Louis Sapperman, the Chief Compliance Officer at Dun & Bradstreet. He actually used social media to solicit feedback, which they incorporated into their code of conduct revision. They delivered their code of conduct through social media and had a social media campaign. So use all of the tools that are available to you. Social media is obviously an important tool, but don't forget the old-fashioned ways as well. You can have posters, you can have meetings, you can have rollout, you can have company-wide stop to roll out the new code of conduct. You can have a multimedia approach. You can physically hand them out to all employees at a designated time. All of these things add up, and all of these things add up to employees who will understand, remember, and recall that you had a code revision, and that's what you're trying to get. And never, never, never forget to document whatever you have done. When you deliver the new or revised code of conduct, I should say, document that each employee has received it. And stay on target, number 6. And the final point. If you set realistic expectations, you should be able to stay on deadline, be able to stay within your budget. You should set aside enough time so that you don't feel hurried, but that you can get it done within the time frame. If your code of conduct needs updating, if it turns out there are other components that need to be updated, or information comes which might lead you to want to do some other things, don't lose track of the ball. Keep your eye on the ball and follow through with the code of conduct, because you need to remember that codes of conduct are really a first line of defense. And the guidance makes clear that the FCPA guidance, I should say, makes clear that they expect a company will put forth in writing its expectations to its employees. And some people think of the code of conduct as inspirational, but your policies and procedures follow under that and give employees specific expectations. So you've got to detail the expectations you have, the internal controls, the practices and procedures, and your disciplinary procedures. These are all going to be considered by the Department of Justice and the Securities and Exchange Commission. If there was really one thing that was driven home to me from the remarks last November and December by Wei Chen, the new compliance counsel for the Department of Justice. She is going to look at how you are doing compliance. How have you burned compliance into the fabric of your organization? And the revisions of your code of conduct, the revisions of your policies and procedures, and utilizing the employees as part of this process, I think are going to be one of the key ways that you can show to the Department of Justice what you have done and how you are moving forward to really burn compliance into the fabric of your organization. And being a good lawyer, I have to end with the following. Whenever you pass out a copy of the Code of Conduct, you need to get a signed acknowledgement. Now, I recognize that most employees will sign most anything you put in front of them, but it is going to be some evidence going forward that you presented the Code of Conduct to them and you've documented that. So that's really my thoughts on the Code of Conduct. And now I'd like to turn to another topic that is often talked about, and once again, I think we need to revisit it, and that is third parties and third-party risk management under the FCPA. And I say we need to visit it again because of the Unaoil case. One of the things that's come out from that is Unaoil received certification and from at least a couple of professional sources that most people would have accepted as very reputable. And it turned out that Unaoil basically lied or dissimulated or hid facts to obtain those certifications and remove any red flags from third parties using them. From companies using them as third parties. And I think the lesson to be learned there is that due diligence and certifications are one part of a third-party risk management system. And so I wanted to use this opportunity to revisit that and try to emphasize what the 5 steps are and how important each one of those steps are. But if one step is lacking or weak, it puts pressure on other steps. So if I could just review with you for a moment the 5 steps of a third-party risk management program. Those are business justification from a business sponsor, a questionnaire to the third party, due diligence on the third party, a compliance terms and conditions, including payment terms in your contract, and then management and oversight of your third party going forward. So business justification. This is a form that should be completed by your business unit employee who wants to retain this third party for whatever reason. Why do you want to use this party? Why this third party as opposed to some others? Do you currently have one under contract that's gone through the process that you can use? What's the reason for having this third party come into a contractual relationship with your company? Why them as opposed to someone else? It also should detail the business services that they're going to bring, so you can evaluate that. Have they been in business? Do they do this type of business? All of those sorts of things. Next step, the questionnaire. But before I go to the questionnaire, this is really something that the business unit must be able to articulate and communicate to you in compliance. The next step is the questionnaire. In the questionnaire, you're trying to get some basic information, and that basic information includes financial structure, financial qualifications, the personnel, references. Are any of the owners, beneficial owners, or officers and directors politically exposed persons? PEPs. Does the proposed third party, do they have a compliance program in place? Are they aware of the FCPA, and have they had training? Now, I recognize that this information is essentially self-information provided, but that's why the next step comes in, and that's due diligence. And here's where Unaoil is so significant. Unaoil was certified by a couple of different recognized law firms and entities as having no red flags present. And it turns out they lied on that. to get those certifications. And so companies that use them were relying on information which was false. The problem in FCPA enforcement is simply because Unaoil lied to a certification agency is no defense to you if you didn't manage that relationship. So you've got to evaluate and address the risk of the third parties, but you're going to have to do that on your own, and you're going to have to do that even if they come to you with certification by a law firm or certification from some other company. So this can due diligence is certainly an important step, but think about what if you're in a country where you can't do the level of due diligence that you want to. After GSK in China, many companies cannot get the level of due diligence they want. So what are you going to do if you can't get that due diligence? Well, that's where you really need to move into step 4 of the management, and that's the contract. And in the contract, you need to focus on some standard compliance terms and terms and conditions, including your payment terms and conditions. So what are some of the standard things that the government has suggested? Well, you need to have a audit clause, and that audit clause allows you to audit them for compliance with the FCPA. To the extent you can get an indemnification, you need to get an indemnification clause, which will be full indemnification for any FCPA violation, including costs for underlying investigation. Cooperation. Require full cooperation with any ethics and compliance investigation, including review of emails, bank accounts relating to the your company's use of that third-party representative. Make any FCPA violation a material breach of contract, which allows you to terminate the contract with no notice or opportunity to cure. That the third party cannot hire sub-vendors without your approval, and that approval would be after they have gone through an appropriate level of review and due diligence. Acknowledgement. Have an annual acknowledgement that they have not violated the FCPA on your behalf. Ongoing training. Require that top management of the third party and all persons performing services on your behalf shall receive annual compliance training, and then every couple or 2 or 3 years at the outset, a requalification as third parties. Now you've got the contract signed, and now your work really begins, and that's the management of the relationship. And I cannot emphasize enough how important this is. That and this is where I think the driving point home from Unaoil will be that you have to manage that relationship going forward. So you've got to have a relationship manager. That should be a business unit employee. Hopefully it's the employee who filled out the business justification. That will be your point of contact with the third party for all compliance issues. They will maintain periodic contact with that third party. They will meet annually to review the third party's compliance obligations vis-a-vis yourself. They should submit annual reports to, hopefully you have some sort of compliance oversight committee, and they will assist the third party representative with understanding and fulfilling their obligations on their contract with you. One of the things that I think you need to consider, though, is having a third-party oversight committee. This is a committee made up of senior executives in addition to the chief compliance officer, and it provides you another set of eyes and a second level of oversight so that it makes sure that all documentation is in place, but also, is this a commercial relationship that we really need? Is this commercial relationship bringing value? If there's a compliance cost, is that cost borne out by the commercial relationship? So I think it's going to be important that you really manage this relationship. So, and then let me just throw out some things that I think would be important for you to consider. So do you have a database of all your third parties with all your information? Is that database accessible? Have you done a risk assessment of your third parties and prioritized them to an appropriate level of risk? What's your due diligence process? Is it based on the risk assessment or is it based on something else? And if it's based on something else, have you articulated that? How are you evaluating the certifications that may have been received from other organizations? Or are you doing your own certifications? Is there someone in your organization who's responsible for the management of each third party? And then finally, have all red flags been cleared? So the unit oil case, it will be with us for some time. How it will play out, we don't know. But I really think that it's driven home the point that a certification is maybe a nice to have, but it's not going to absolve you of potential FCPA liability going forward. So I would hope you would consider a strong 5-step management process, and your work really begins after the contract is signed. You've got to have invoices. You've got to pay based upon services delivered. You've got to review those invoices on a regular basis. You have to work with your with your third-party representatives. You have to continually communicate your expectations to them. If you put that type of work in and it does all go south on you, perhaps then you'll have a defense. But simply claiming that they were certified by a well-known third-party certification agency is not going to protect you going forward. This is Tom Fox. I thank you very much for listening, and I look forward to visiting with you again. Hello, everyone. This is Tom Fox. I'd like to thank you again for listening to this episode of the FCPA Compliance and Ethics Report. As I mentioned, I am participating in several roundtables, upcoming roundtables for the Red Flag Group. Once again, they're going to be in Atlanta, Minneapolis, Dallas, and Houston in June. Please check out the Red Flag Group's website. The roundtables are free, and you'll really get a lot of good information on how you can manage your third parties in light of these two very important public events, the Panama Papers and the unit oil case. This is Tom Fox. I'd like to thank you for listening and look forward to visiting with you again.